This is an application by Dr. Azmi Sharom for an order that the Sessions Court refer to the High Court for its determination the constitutionality of Section 4.1 of the Sedition Act 1948. Dr. Azmi also seeks an order in consequence thereof for the charges against him to be stayed and or struck out. Dr. Azmi was charged, as you all know, on the 2nd of September for 2 offences against Section 4.1 of the Sedition Act. Now, as the orders sought through this application deal with issues of constitutional concern, the Sessions Court has the power to transmit the matter to the High Court for its determination of the matters raised under Section 30 of the Courts of Judicature Act 1964. This is important. In essence, the grounds that we advance in support of the application are as follows. Number one, we say that the Sedition Act was not enacted by Parliament. Article 10 of the Federal Constitution guarantees freedom of speech. Article 10.2 expressly states that only Parliament, and this is important, only Parliament may by law impose restrictions on the rights conferred under Article 10, which we say guarantees freedom of speech. The Sedition Ordinance was enacted in 1948 prior to independence. Subsequent to that, it was revised through a Law Revision Commission and gazetted as law. Right? So it does not go through Parliament. So our position is, as it was not passed through Parliament, it cannot restrict the rights offered or guaranteed to Dr. Azmi Sharom under Article 10.2 of the Federal Constitution. Our position is that it is therefore unconstitutional. Now, we've also filed a certificate of urgency today to expedite the hearing of this application. Now, I hope that the Attorney General supports our application for the matter to be transferred. Yeah? So this application, the first part of it is that it has to be transferred to the High Court so that the High Court can determine the issue of the constitutional issue that we have raised. So for that particular stage, in other words, transferring it from the Sessions Court to the High Court, I hope the Attorney General does not object. So I ask the Attorney General's chambers to recognize that there is an issue of constitutional significance here, to come to the Sessions Court and to accept and concede that this is a matter that should be referred to the High Court for its determination. Right? So in that regard, we ask and we hope that they will not object. In the same time, I also hope that the AG will consider staying, holding all prosecutions in sedition cases pending until this matter is determined, because this is an issue that will affect all cases involving persons who have been charged under Section 4. Yeah? So as this matter may affect those cases as well, is our position and our hope that the Attorney General will accept that there is an application pending before the High Court and to stay all prosecutions until this issue is determined. Okay, any questions?
Is this the first time that the constitutionality is being challenged?
I think on this ground, this is the first time. In Haris Ibrahim, we filed a similar application in the High Court. But what happened was there was a technical objection taken by the AG chambers. The AG chambers were of the view that we should move an application in the Sessions Court itself and ask for an order under Section 30 for the matter to be referred to the High Court. So this is what we are doing now in Professor Azmi's case. Yeah, so it has never been taken on the merits, although there is another application, but that was actually knocked out on procedural grounds. In fact, Haris Ibrahim's matter came up before the Court of Appeal last week. The Court of Appeal affirmed the High Court's decision, which of course puts us on a back footing. Then we are back here in the Sessions Court. Of course, we have taken Haris Ibrahim's matter to the Federal Court because we want a ruling on Section 30, but that's a separate matter. Coming back to the question, in answer to it, the short answer is this is the first time, to my mind, to my knowledge, that an application is being moved under these grounds to declare Section 4.1 of the Sedition Act unconstitutional.
On these grounds?
On these grounds.
Usually how long will it take to...
I've asked for, we filed a certificate of urgency, so I'll get, perhaps try and get an early date. We're hoping that we can get a date by next week. I think Professor Azmi's case is fixed for case management the 3rd, if I'm not mistaken, 3rd of October. Yeah, so we need to have this heard before the 3rd, because our position is that if the Sessions Judge is with us, that it should be transferred, it should be referred to the High Court, then all proceedings should be stayed. So we do not have to go through the process of case management on the 3rd. So we're trying to see if we can get a date fixed either next week or early the following week.
Of course, ideally, the Sedition Act should have been gone already, because it was promised that they were going to get rid of it, but it's still here. So while it's still here, we have to make sure that we challenge it as far as we possibly can, legally.